welcome everyone to our MDT webinar. Today we are covering the role of the prosecutor. We have two really spectacular presenters for us today who are going to walk through some really important content to hopefully enhance your multidisciplinary team. Let's get started. Just a disclaimer, this is a grant-funded project. If you have any questions about this, you can feel free to contact Kylin or Grace. I believe both of them are here, and I'd be happy to connect you to as well as if you have any questions regarding specifics for your MDT. They are the people to connect with. And our two presenters today, I'll introduce myself first. My name is Anna. I'm the Training and Technical Assistance Specialist with NCALL, helping put on this series of MDT webinars. And today our presenters are Tara, who is the Senior Prosecutor in the Office of St. Paul City Attorney, a wonderful resource here, and my colleague Anne, who is our Justice System Coordinator at the National Clearinghouse on Abuse Later in Life. So you are all in really great hands today with your content. They'd be happy to answer any questions either in the chat box. One of them will be monitoring that throughout, as well as towards the end, we'll have their contact information. So if you need to reach out for any clarification on content, or if you want to connect for any other reason, their emails will be there as well. So keep a lookout for that information. All right, so I'm going to turn it over to our presenters, and we will start with learning objectives.
Great, thank you, Anna. If you could have the next slide, please. Today we are going to, we've got 3 learning objectives. We are going to, after this, you'll be better prepared to describe the role of a prosecutor and exactly what happens when they're handling an elder abuse case. We're going to talk about both the benefits and the challenges related to prosecutor participation on MDTs. And then Tara's going to talk at the end about some ways that you can better engage with local prosecutors and encourage their participation on the MDT. You'll see, next slide please, that much of this content we actually adapted from a really great NICEAC publication called The Role of Local Prosecutors on Elder Abuse Multidisciplinary Teams. It's very long, it's very detailed. I will pop a link to that in the chat, and I would really encourage you guys to look at that if you want to dive deeper into this topic. So we're going to start with a poll, and I think because it's such a small group, maybe you guys could just either chime in, like have your camera and mic on and chime in, or enter your feedback in the chat. But we're wondering what your experience has been in engaging prosecutors with your MDTs. Have you been successful at doing that? Have you had challenges? Are there things that you're looking for out of today's webinar that are related to this topic? Just looking for your experience in this area or what you're hoping to gain from today's session.
Hi, this is Joni, and we do have Patet, who has a senior team with their legal department for the poor and the vulnerable that works with our committee. But how would you engage other prosecutors? Because I know that in our area, we have Neighborhood Legal Services and Patet who really do work with the more poor and vulnerable populations. But what about those prosecutors that that do handle cases like this, but not on a regular basis?
Okay, excellent. My very favorite professor in law school used to work for Patet, so I know a little bit about what they do. Any other experience you guys have had with engaging prosecutors or challenges, or If you think of any questions that we're not addressing as we go along, or you have anything, as Anna mentioned, please feel free to put that in the chat. So next slide, please. I think we want to just start out by pointing out, talking a little bit about why prosecutors are an important part of any MDT. And that is, I think that ultimately there are some really important shared goals. The goal of an MDT is to respond to elder abuse in a way that advances the well-being of older victims, as well as justice for older victims. And of course, the role of the prosecutor is seeking offender accountability, and then also enhancing victim and community safety. So clearly there's a lot of overlap there. We're going to start today by having Tara talk a little bit about the role of the prosecutor specifically in handling elder abuse cases and in all cases. So I'll turn it over to you.
Thanks, Anne. Next slide, please. And next slide, please. Thank you. So hi, everybody. I'm really excited to be here just talking about my experience with MDTs. I've worked with a lot of communities through NCALL and just in my work as an elder abuse prosecutor. And I know that being a part of an MDT for a prosecutor can be really transformative in the way we see our cases and in the way we do our work. And so I'm one of the biggest cheerleaders for prosecutor participation in MDTs. And I think, if I can be so bold as to say, I also think that the prosecutor has a lot to offer the MDT as well. So it really is a two-way street. So just as we start today, just a little bit in general about the role of a prosecutor. A lot of this you probably already know. Of course, the prosecutor has the sole decision-making authority on whether a case gets charged. We have to base that on what we can prove beyond a reasonable doubt, which is a really high standard, of course. We always encourage elder abuse prosecutors, really more than any other, I think in any other kind of case that I've handled, it's so important for prosecutors to get involved with the investigation really early on and be really a part of kind of driving the direction of the investigation. And part of that also involves, because many of these investigations can last a long period of time, making sure that victim needs are being met throughout the investigation, and that also that victim input is included and considered as part of the decision to charge, which I think the MDT can play a big role in. Prosecutors, of course, work with experts and forensic accountants on financial exploitation cases, social workers. We may or may not have an in-house victim advocacy program or community advocacy organizations that we work with. It really depends on the size of your jurisdiction. Some prosecutors' offices really rely solely on community advocacy organizations, which can be tricky because, of course, community advocacy organizations enjoy confidentiality in a way that system advocates don't. And so, and that's another point that can be discussed and kind of learned about within the context of an MDT. Once a case is charged, we can always ask for a protective order. I shouldn't say always. Often we can ask for a protective order as part of the criminal case, but that of course isn't until the case is actually charged. And so someone on an MDT can help maybe assist a victim in getting a civil order or some kind of protective order prior to a case getting charged. Of course, our goal is public safety and offender accountability. And I really, for myself, I consider those in that order. I think victim safety should always be the first priority, and offender accountability a close second. And as I mentioned earlier, we really can be a critical component of an elder abuse MDT. Next slide, please. Oh, I think you went. Oh, wait a minute. Okay, I got out of order. I was thinking you were out of order. I was out of order. Okay, next slide, please. As I mentioned, I think we're going to now talk a little bit about some of the benefits to a prosecutor of participating in an MDT, and then we're going to talk a little bit about maybe what some of the challenges can be for a prosecutor participating in an MDT, or maybe some of the concerns that prosecutors might voice. And of course, we want to talk about kind of ways to overcome those or navigate those concerns. I really think that in my own experience, being a part of an MDT really changed how I saw cases and really more particularly how I worked with victims throughout the pendency of the case. So as Anne mentioned early on, we relied heavily on some content from a New York City Elder Abuse Center project that was done in 2018. And as part of that project, they interviewed a number of prosecutors in New York and talked to them about their experience on MDTs. And these are a number of the benefits that were listed by those prosecutors. And as we were preparing for today's discussion, I went through and kind of added some of my own content based on my own experience, and then based on also, again, working with other communities around the country. And these are really consistent in terms of what we see. Having access to experts, quick access, I think, is the key. Being connected with resources that can assist a victim, being both the receiver of education and being able to educate other partners in the community on the criminal justice system and how we charge and manage cases. Those professional relationships that we form as part of an MDT really are key, because it quickens the process. If I'm working on a case and I need to, I have a quick question maybe about how something might be managed for a victim, being able to reach out to a partner that I've met and know on the MDT really makes a big difference. So it makes everything more efficient. I think it does help minimize the work that we do, the duplication of work, and all in all strengthens our case. And we're going to go through kind of each one of these and talk in a little bit more detail. Next slide. So having access to expert and key decision makers in the case. If you are an MDT coordinator, I would say it's really important for you to reach out and try to find a forensic accountant, a geriatrician, geriatric psychiatrist, all of those folks who may at some point have something to offer an elder abuse case. And they may or may not want to participate as a standing member. But what we've done in my own MDT is we've invited them as a guest or as someone to just come in and do a short, maybe half-hour presentation on the work that they do. And then when they see all of these people in the room who are there for this common purpose, often they'll be interested in wanting to be a part of the group. It's really important to have that quick access, as I mentioned. If I need to establish, for example, a victim's capacity in a case, being able to access a geriatric psychiatrist is really key, and being able to access that quickly. In financial exploitation cases, of course, forensic accountants can play a big role. And I have made a connection with a forensic accountant in my community through my MDT. Being able to just discuss items that a forensic accountant may be able to speak to, even if you're not wanting to hire that person and pay the fees associated with that. My office has a really small budget, as most prosecutor offices do. And so having someone that I can just shoot a question by or run something by really makes a big difference. It saves time, it saves the cost of expert fees. It really makes a difference in that regard. And I think in especially smaller jurisdictions, the prosecutors on the elder abuse cases that might be handled in that jurisdiction may not do just elder abuse. And so they may not have expertise on all the various agencies that may be involved in an older adult's life, or that may be involved in an elder abuse case specifically. They may not have occasion to reach out to ABS with any regularity. And so making those relationships with all of the different team members on the MDT really make a big difference. It makes us just better prosecutors overall on elder abuse cases. Next slide, please. I think victim assistance is probably the biggest area that I see a benefit as a prosecutor. Prosecutors aren't social workers, and but we really do want to do what's best for victims. And so having access to a group of people who all are there for the common purpose of serving older adults, and in various ways, whether it's mental health or shelter services, housing, all of those various things that an older adult or any victim may need. It's really key. I think it really has, talking with an MDT about your case can really help ensure that you stay victim-centered. Prosecutors often can be more sort of tactical, and we're thinking about the laws that apply and all of the things that we need to prove, but it really does help me stay grounded in staying victim-centered in my case. And I think by listening to people with expertise in assisting victims, we're more likely to choose a resolution that will positively impact the victim's life long-term. And then lastly, if you have, often elder abuse prosecutors are pulled from people who are doing domestic violence prosecution. And so that's sort of their frame of reference. And many traditional intimate partner violence resources that are in your community just may not be appropriate, or may not even serve older adults, particularly male older adults. We have many more male victims in the elder abuse cases that I handle than we do male victims in the intimate partner DV cases. And a lot of the community resources only serve females. Is there shelter appropriate for an older adult? Is there support groups that are accessible and appropriate for older adults? Addressing cognitive issues, guardianships, there's all these additional layers that exist in elder abuse cases and working with older adults that just aren't there for the younger community. And the MDT can really be pivotal in addressing those needs. Next slide, please. So learning what, when I was new to elder abuse prosecution, I leaned heavily on the MDT to just learn about the various agencies that are involved and what they can do for older adults and what they can't do. I think a really important component of any MDT early on is having educational courses or training sessions on what each member of the MDT can do. And what we did early on is we would have, okay, this meeting is going to be dedicated to APS, talking to the rest of the people in the room about what they do, what their limitations are, what their confidentiality rules are, what their standard of proof is, all of those things. The prosecutor does the same thing. And I think by having each agency do that, I didn't know I had never heard the term ombudsman when I started doing this work 20 years ago. It really can make a difference in when we all gain a real good understanding of the roles, the priorities. If we all come at it with a basic understanding that everybody is there, everybody who's at the table is well-intended and doing everything they can to assist an older adult and to assist in an elder abuse investigation, and sort of starting with that basic understanding really builds trust in the group and just builds trust in the work that we're trying to do. I'll also say that the MDT has really been pivotal in cases where I can't charge, where everybody in the room agrees that a really awful thing happened to this person, but I'm not able to prove beyond a reasonable doubt that this is the person that did it for whatever reason. And it's important for prosecutors to talk to the group about, here's what my limitations are. I'd love to be able to charge this case. Here's one element that I'm not able to prove. Now, sometimes you may have people in the room who are able to give you information that actually changes that outcome. But even when we're not able to get there, the MDT can be pivotal in helping making sure that a victim's needs are nevertheless met, doing things that can protect the victim from the perpetrator, even when we're not able to charge the case. And if anybody at any point has questions, or I don't know, Anne, if we're going to try to do questions at the end, or it's a small enough group that, you know, throw a hand up and I'm happy to answer questions, or we can just stay to the end too.
Yeah, I would agree. I think as we go along is fine. And if people want to put their questions in the chat, or if there's a point you want clarification on, just pop it in the chat and we will catch it.
Okay, thanks. Next slide, please. So I think I kind of touched on this when I was talking about the education component. Building those relationships on the team and having a name and phone number or email in your, well, I'll say Rolodex. I still have a Rolodex. It's another webinar. But building those relationships really does do a lot in building trust amongst each other on how we're playing our role. It just really helps for all of us to understand, and it expands the sources of information that we have on our cases. And very often, I'm learning something through my MDT that makes a difference on my case, whether it not always necessarily makes it chargeable versus not, although that has happened. But just learning little components. Who else had access to this victim? Are there ways that we can address the housing needs? Now, many of the discussions that happen in my MDT, and I think in most, is we're discussing neglect cases. It's self-neglect, I should say. And prosecutors don't play a role in self-neglect cases because there isn't a perpetrator. However, listening to those conversations, just being in the room and learning about all of the various things that the professionals and agencies can do for a victim who's experiencing self-neglect really has helped inform the way I handle my criminal neglect cases. Okay. Next slide, please. So as I mentioned, MDTs save time. Having quick access to the various professionals that are around the table makes a big difference. We can learn a lot about individual cases. We can learn about what everybody's role is, and that makes it that learning curve doesn't have to happen with each case. It happens because we already know. I know who can help with housing in the room. I know who can help if I have an older adult who has experienced sexual assault. I know who can help if I need to talk to a forensic accountant. I have a guy that I can call. It really makes a big difference, and it makes things run just a lot more smoothly. The other thing is, particularly in financial exploitation cases, there's so much to be done. There's often, especially in the larger cases, just so many layers to those cases, and the investigations just can really go on for a very long time. And so the MDT can help us in not only helping kind of build the case and, you know, answering questions like who else had access to the victim, did the victim have capacity at the time of the exploitation, but also helping do sort of stopgap measures like stopping the bleed of money that's continuing to go to the perpetrator during the course of the investigation. There's a lot that can happen that the MDT can play a role in that makes things just run a lot more smoothly. And the one thing I'll add to that too is that through the MDT, I can often learn who a sort of a safe bridge person is. If I have someone who's really significantly declined cognitively, and I want to be able to talk to someone else in the family about the case, whether we're arranging a visit to go talk to the older adult in their care facility or in their home, having someone that I know isn't a potential suspect and that really has the well-being of the older adult in mind can make a big difference. And I'm often learning of that person through somebody at APS or somebody who's in the room at our MDT meeting. Next slide. So overall, what I'll say is that cases that are discussed at an MDT are often stronger, they're better developed, and the victim's needs just overall are more thoroughly addressed. As I mentioned earlier, being able to assist victims short term, even when either the investigation is still pending or we're still deciding whether to charge it, or now with COVID, our cases are languishing through the system for so long. It's just, and I know we're not alone in that. Jurisdictions all over the country are varying, dealing with this, but we have thousands of cases that are backlogged, which means that our cases are sometimes taking over a year to get through the system. We're able to, thankfully in Minnesota, we're able to ask for a speedy trial when we have a vulnerable adult or an older adult who's a victim, but it doesn't do a lot of good when we don't have judges in courtrooms to hear the space to hear the cases. And so the MDT can really be pivotal in just making sure, again, as I've mentioned, that the victim's needs are met throughout that process, and then helping with communication, particularly with someone who's cognitively impaired. Prosecutors aren't as skilled necessarily in working with an older adult who has either mild or significant cognitive impairment. And so I'll often lean real heavily, as does the investigator. The law enforcement on our team will lean real heavily on APS during interviews or really throughout the investigation to assist, because they really are skilled in, that's what they do every day. Next slide, please. Okay, well, that's the maybe not entirely exhaustive list, but I think we've covered most of the benefits of prosecutors to prosecutors of participating on an MDT. And now Anne's going to talk a little bit about some of the challenges. Oh, wait, no, she's not. I'm going to.
Scared me for a second.
Yeah, sorry. Back to you, Anne. All right. So next slide, please. So one of the challenges that that I think of prosecutors participating on an MDT is just expectation management. And I think largely that falls around what we can and cannot charge. It's really frustrating when everyone in the room, as I mentioned, knows that something really awful has occurred, and we have a real good idea of who that person is, or we know who that person is, and we're not able to prosecute the case because we're not able to prove it beyond a reasonable doubt. As I mentioned early on, I think prosecutors educating the rest of the people around the table on what our charging standards are, even just how the criminal justice system works, because not everybody in the room is real dialed into the operations of the criminal justice system. We all tend to, operate in our silos as much as we try to avoid that. But inevitably, we just don't have expertise on how everybody's system works. So it's really important, either whether you invite a prosecutor as a guest because they're not yet on your MDT, or they're on your MDT, having them come in and just talk about what their charging standards are. They also vary. I mean, yes, proof beyond a reasonable doubt is our standard. However, how that gets interpreted, and what the individual DA's office or city attorney or county attorney's office, what their policies and practices are around charging, is something that prosecutors need to educate the rest of the people in the community about, or particularly the other professionals on an MDT. However, we really, we shouldn't measure our success solely on whether a case gets prosecuted. There's so much other good work that happens through the MDT that a prosecutor can either play an active role in, or can just be there to observe and learn. I've learned so much about the myriad of resources and different agencies in the community that work either directly with older adults or around the different needs that an older adult has. One of the things I'm trying to One of the things that can be a challenge, and I think was a challenge for us early on, is that APS has a different standard than, and they operate under a different proof standard, and that often is a preponderance of evidence, which just means that it's more likely than not that something happened. And so that will drive licensing issues and other determinations that are made by APS, whether it's state or local APS. And so that was a big component early on for us educating each other on, you know, what the difference is and why one thing can be provable with one agency or at one level and not at another. Next slide, please. Oh, and as that was turned, I realized, yes, in terms of timing of meetings, I think as long as everyone knows that if you're scheduling meetings in the afternoon, and prosecutors often, I mean, I think noon hours, as much as everyone hates noon hour, well, here we are at a noon hour webinar, but as everyone really doesn't like noon hour meetings, for prosecutors, that's probably the best thing because, again, in terms of managing expectations, we're often called into court in either morning or afternoon, and so meetings at that time can be challenging. So information sharing can really be probably the biggest thing that comes up. Confidentiality rules is probably the biggest thing that comes up in MDTs. And when I talk with other prosecutors who are reluctant to participate, this is what they usually go to. I will say the number one way that you can address some of those issues is having an MOU or a confidentiality agreement in play that everyone who attends every meeting signs at every meeting. And so what we've done is we just have a printed form that has the components of the confidentiality agreement. There's a signature line for each person who comes to the meeting, and we all sign and have that understanding. Early on, when any new member starts, it's important to you know, that you explain this is our confidentiality agreement. This is what it means. This is what we can and cannot talk about. And that when they join, they talk about their own agency's confidentiality rules. So everybody understands that, you know, gosh, I was hoping that having this person from who's a sexual assault advocate, I was hoping to be able to get a lot of information from her, for example, about what this, where this victim is living. I'm trying to find this victim and now I can't find her. I'd love to be able to ask the sexual assault advocate where she is. And I know I believe she's working with the victim, but I don't know that for sure. And then you go and you ask the advocate, and of course they can't tell you because victims enjoy confidentiality with community advocates. If I didn't know that, then I'd probably have a problem with the person who's in the group. So again, education just really goes a long way. Grand jury evidence, limitations on the use of grand jury evidence. Of course, grand juries, A, they can't be used as fishing expeditions, and B, most importantly, the information that a prosecutor learns through a grand jury or through the grand jury process is not anything that we're able to share. And it doesn't matter if we have confidentiality agreements or MOUs with an MDT, we simply can't share it. So again, letting everyone in the group know that ahead of time, even, you know, if people question, showing them the rule that says we're not able to share that information can go a long way. I think one of the bigger challenges as prosecutors is just balancing our role as MDT members and officers of the court bound by discovery rules and Brady obligations. Brady versus Maryland is a case that essentially just says that prosecutors have to disclose all exculpatory evidence, and exculpatory evidence is just really anything that's favorable to the defense. So if I'm sitting at an MDT and I learn something that's exculpatory about a case that I'm handling, then of course I would need to disclose that information to the defense. And discovery rules, frankly, can even be broader. Your state's rules may, in Minnesota, for example, we are required to turn over anything about the case. And different prosecutors, frankly, in different offices may interpret that language differently. But it is important early on for the prosecutor to share that information with everybody in the room. I have seen situations where a prosecutor will remove him or herself just if they know ahead of time that that her case is going to be maybe a case that's already charged and going through the criminal justice system. If you know that that case is going to be discussed at the MDT, you may decide not to go to that particular meeting. It doesn't mean, of course, that you remove yourself completely from the MDT process, but you could decide that depending on what's being discussed. There's a lot of fear about learning. Well, I don't want to learn about anything that's I'm going to have to disclose. At the same time, if there's something exculpatory that exists in the case, I want to know about it. I mean, it makes us. I want to know about it earlier. I'd rather learn of it during an MDT meeting than learn of it when I get a witness list on the eve of trial that says all of a sudden there's this information that I could have known had I learned it earlier. So disclosure concerns are certainly serious, but they are manageable. MDTs have navigated these disclosure concerns for years and years and years, and I think again overall the benefits that a prosecutor has from participating in MDT far outweighs some of these concerns. And if you are just careful and share information with each other about these different rules, the Brady concerns and the discovery concerns, I think it can just go a long way in making sure that there isn't the cases don't get compromised, that victim safety doesn't get compromised as part of the MDT. Again, make sure that you if you are going to be discussing individual cases, and some MDTs do a lot of case study work, individual case study work, and some may do more with sort of systems change. And but if you're going to be discussing individual cases, I think it's really important to post an agenda ahead of time so people can make decisions about whether or not they want to appear. And then, or even can kind of reach out to other people who are on the group and saying, hey, what are you going to bring to the table? Because I want to know if this is something that I should appear on or if I should avoid. Okay, next slide, please. I would say that, yes, MDTs, like any meeting, can be time consuming. I think the value of participating on an MDT so outweighs the burden of it that hopefully you're not going to have someone that just says, oh, I don't have time. I think that it's really that the MDT coordinator really plays an important role in just being a leader in the group, making sure that all the conversations are professional, that people are that aren't getting defensive, and these cases are really compelling and they're really important, and there's lives at stake. So people can get pretty heated, especially when someone isn't agreeing with how someone's proceeding on a case, or as a prosecutor, if people are really upset that a case isn't getting charged. Though it's important to have those conversations, not to avoid them just because they're hard. But the MDT coordinator, I think, can play a really pivotal role in just making sure that everybody's playing fair and staying professional. I think it's important to have particularly with the prosecutor, and that's probably true with every profession, having a backup person if they're available can be really helpful. And I would just say, in terms of the prosecutor participation, if you're deciding kind of who to invite, pick the right prosecutor in the sense that you want somebody who's passionate about elder abuse cases. Sometimes what will happen is that what I've seen is that a project coordinator will reach out to the head DA and say, hey, we're starting this group. please assign someone to come to the meetings, and someone gets voluntold that they're going to be on an MDT, and that's not always a good fit. I think if you have cases that have been handled in your community and reaching and whether it was a sort of a favorable outcome or not, if you were impressed by how that case was handled, I'd say reach out to that individual prosecutor and tell them about your MDT, invite them to just come to a meeting and learn more about the work that you do, and hopefully that would be something that they would see a value in and want to participate in. I also think it's important to have somebody who's passionate about elder abuse cases. It's also important to have somebody that has the humility to really actively listen to everybody in the room, to the feedback, the really valuable feedback that people have and the information that people have on your cases. There have been situations where we've had a case that we just don't think is chargeable, and you get more information, and it turns out it looks like we're maybe getting closer, but you have to have somebody who's willing to listen to everybody in the room and just really having that sort of air of professionalism and respect. Next slide, please. So Anne's going to talk a little, oh, sorry.
I'm just gonna jump right in. Thank you, Tara. I know you guys all wish now that you could have Tara on your MDT. And we do too. You can go to the next slide, Anna. I'm just going to talk briefly. There's a lot of overlap between these sections because many of the benefits that prosecutors see in participating and being active on an MDT are the same benefits that the MDT sees. So we're going to just walk quickly through these and just really talk about how it strengthens the MDT to have a prosecutor who is actively engaged with its work. Next slide, we'll start with access to prosecutors and relationship building. Again, it helps, just like it helps the prosecutor to know, who are the victim services people, who are the active APS folks, who do I need to contact about transitional housing for an older victim. It's great for you guys to know if they're, does your DA's office have a designated elder abuse prosecutor? Is there a team that works solely with cases involving vulnerable victims, that kind of stuff. So getting to know and being able to contact the prosecutor is very useful. As is learning the differences between different DA's offices in different jurisdictions. There is so much variety between and among offices that if you worked on an MDT in one community and then moved somewhere else, you could very well have different policies, different protocols that would be good to know. So that's another benefit for the MDT. And then also, it's just really, really good because of the nature of these cases to have somebody around the table who does have expertise on criminal law and court processes. And the prosecutor clearly would fill that need. Next slide, please.
I would also add to this, Anne, that if you can get a judge to come as a guest, they're not likely to participate as an ongoing member. Although if you have a judge on your MDT, hats off to you. But mostly I think people are having difficulty getting a judge to sit on their MDT for a variety of reasons. But if you can have one come as a guest, it really can be educational for, yes, you as the MDT, but more importantly for the judge to just know that there's this group working on these kinds of cases. And they will then often turn to the MDT as a resource.
And that I just really want to underscore something that Tara said at the beginning, and that is if you are having trouble engaging with somebody, and certainly it would be great if this worked with a judge, but invite that prosecutor or invite that judge to come and present, and just starting to build that relationship may make them see the benefit for them in becoming involved with the MDT and seeing that is a mutually beneficial relationship to have. So another benefit for the MDT is accountability, both at the systemic level and individual level. When you have a prosecutor who is participating in discussions with the MDT, it's going to be an opportunity for them to learn about potential gaps in service, in the community? Where are people falling through the cracks? Where is there a legal issue that could be addressed through the criminal justice system? And where is there accountability that needs to happen? So I think that is huge. It is the same with any of us who work with teams, whether it's professionally or outside of our work lives, that accountability aspect can't be discounted. Tara, is there anything you would add about that?
No, I would echo the accountability piece. I think, unfortunately, we don't get any calls from the community, or there's nothing in the paper when we don't charge an elder abuse case. However, being part of an MDT, I think really kind of shines sort of brings these cases out into the forefront, and shines a light on the cases in a way for everybody in the room, but for the prosecutor as well, to just really learn that there are a lot of people, everybody in that room cares about this older adult and cares about the outcome of that case. And I think that, I really take that to heart and take it seriously. So not only are in making sure that I'm doing everything I can on the case, but also then sharing the information on what I can't do with the group.
Cool. Thank you. Next slide, please. Tara did talk a lot about the team education aspect of this. So many folks who are on MDTs don't, by nature of their professional lives, just don't have experience in the criminal justice system, and maybe don't know how these cases move through the system, how the court system works. If you don't have reason to know about that, it's likely that you wouldn't. So I think that the opportunity to have team members educated about the law, about what is needed to prove these cases, the various forms of abuse, various crimes against older adults. As Tara mentioned, lots of times we hear about something horrible that happened that didn't get charged and nobody was held accountable. Well, there are many reasons that could be the case, and I think that having a prosecutor participate on the MDT can help folks sort of understand how those cases happen, how they get charged or how they do not get charged. And I do think that team members do get a more, we think of prosecutors as the folks we see on TV that are just putting folks away on Law and Order. And I think that there's a lot more nuance to it, particularly with these kinds of cases. And I think it's a terrific educational opportunity for the MDT. Next slide, please. Tara talked about this and cases that make it into the media or don't. Having a prosecutor on your MDT can sort of give the appearance of strength, or adding some teeth to the work of the MDT. They can also bring their own skills in interviewing, preserving evidence. Preserving evidence is something that that all of us in our different roles, professional roles, may have to do one day. So what does that look like? They can teach the team about that. And then interacting with law enforcement. Most prosecutors have relationships with the investigators and detectives in their local police departments. How can they have a role on the MDT, or how can we best interact with law enforcement with our goal in mind of holding offenders accountable and keeping older people safe? Finally, if there is a case that is in the media and the DA or an ADA is participating on the MDT, that could very well bring some attention to the work of the MDT. So I think that that's something that is worth thinking about. Probably none of us, before we came into this work, knew about MDTs, or if you work at the bookstore down the street, you might not have reason to know that MDTs are even a thing that exists. So I think having that sort of higher profile member can potentially raise awareness of MDTs themselves. Anything you want to add here, Tara?
No, I think you covered it, Anne. Thank you.
All right, next slide, please. A really crucial part, I think, of having a prosecutor participate on your MDT is that prosecutors have such an array of tools and resources available to them that lay people generally may not know about. And a lot of that involves alternatives to prosecution. So team members might have information available to them that can play a role or have an impact on the charging decision that a prosecutor would be making. If you don't know about diversion programs or deferred prosecutions or specialty courts, that is something, and Tara's going to talk a little bit about those, but there are specialty courts that handle cases where somebody has an AODA or mental health issue. There are domestic violence specialty courts. And I think that when you have a court that is designated to handle cases with those underlying issues, they're much more effective and they're much more creative than just having somebody go through a normal, docket that could include anything, any sort of case. So it's important to understand the different kinds of prosecution alternatives that might be available. Prosecutors' offices often have staff, again, depending on the size of the office, but they're going to have victim witness staff, social workers, their own investigators. Larger jurisdictions might have their own forensic accountants, case coordinators, that sort of thing. So you'll get to know the staff at your DA's office and what is and is not available. Anything you want to chime in on there, Tara?
No, I think on the next slide, we'll talk a little bit about different outcomes or restorative justice in elder abuse cases.
Okay, so let's go to the next slide. As many of you know, I know that you know, one of the biggest barriers to older victims of abuse reporting is that frequently the person who is hurting them is also a family member and is often someone they love. So that person, the victim, may just want the violence to end, but they don't want to see their loved one go to jail. There are many barriers to why people do not report, but that is a big one. So I think when you provide alternatives to incarceration, a victim is going to be much more likely to participate in the investigation. If they know that what could happen is their loved one, who is also harming them, may get the help that they need. They may have AODA issues. They may have underlying mental health issues. So that's really, when you think about an older victim, thinking, well, if I call the police, obviously what's going to happen is my son is going to go to prison, and that may not at all be what they want. So Tara's going to talk a little bit more about specialty courts and some of the alternatives that are available.
Yeah, and this really varies from jurisdiction to jurisdiction, so we won't get into a lot of detail. But overwhelmingly, in the cases that I have handled, victims don't want jail or those kinds of outcomes for when the perpetrator is their adult son, daughter, grandchild, and it's heartbreaking to see the amount of exploitation and abuse that an older adult will live with just to protect their loved one. And they are very often, I shouldn't say they, because it's not an always thing, but many victims really do that's the number one thing that they want, more than being made whole, even sadly sometimes more than being made safe. They want help for their loved one, and that is where specialty courts can come in. Mental health court is something that may take a very long time. It's not as quick as other traditional prosecution, but the person may be coming in monthly or every other week for a long period of time to just make sure that they're maintaining their mental health care plan, being med compliant and other things. Substance abuse court, of course, works the same way. We also have a veterans court for people who are experiencing the effects of that. Those kinds of courts are most often, not always, sometimes they may have a jail component or prison component to them, but most often they are a way to avoid, to really just treat the underlying condition of the perpetrator and not necessarily send them to jail or prison sentence. Diversion, similarly, however, with diversion, in the end, you don't end up with that criminal conviction, because that's another thing that older adults, in my experience, are really concerned about, is the collateral consequences that are going to come from even just a conviction, to say nothing of the jail time and prison time. They don't want their loved one to be convicted of an assault, because gosh, then they're not going to be able to get into housing, or they may have issues with their profession. So those are things, ways that we can address the underlying issues, try to keep victims, I think they're more effective in keeping victims safe, frankly. And then lastly, of course, there are across the country in many, many jurisdictions, we have restorative justice programs. And there's really a lot of emerging work that's being done in this area, particularly for elder abuse cases, because of the things that we've already talked about. Mediation can be a way to address some of the issues, and also maybe get restitution, or at least work towards making the victim whole in some way. Peacemaking circles may be a way to intervene, where the perpetrator goes to a group of community members and talks about the impact of, and learns about the impact that their crime had on the victim and on the community. I think those aren't always appropriate. You have to be careful with something like that, in all of those situations, mediation or peacekeeping circles, a victim would need to be able to consent or agree to participate in those. Victim impact is crucial in really any of these specialty courts or restorative justice programs, and making sure it's aligned with both their safety and their wishes in the outcome. And I think also, being part of an MDT, there are times where there will be enough to charge the perpetrator, but based on everything I've learned from the people who are working with the victim in the community, or different agencies on our team, I may make a decision not to charge a case, and won't even necessarily go through mental health court or diversion or restorative justice programs. There may be good reasons not to charge a case. It doesn't happen that often, but I think, again, making sure that victims have, I think when risk is lower, risk for reoffense, then victim autonomy should be really high. When risk to victim safety is high, then unfortunately often victim autonomy will sometimes have to be compromised in the interest of safety. But there's a lot more that we could talk about with these different restorative justice programs, but we probably just don't have time to delve into those today. But if you are considering something like that for your community, there are a lot of resources out there that talk specifically about how they should be addressed in elder abuse cases, particularly when you have victims with cognitive impairment and things like that. Next slide.
Thanks, Tara. I know that we are out of time, so I don't know if people can hang out, or if you want us to just sort of like highlight the last few slides, Grace or Lisa. I don't want to overstep folks' time. Would take advantage of people being here, but we have just a couple more on the challenges. Obviously there's lots of benefits from the MDT perspective. There are also a few challenges. If you can go to the next slide, in terms of expectation management, as Tara talked to, differing expectations about what should happen with cases, what cases should be pursued, and why. The difference in standard of proof between civil cases and criminal cases, preponderance of the evidence versus beyond a reasonable doubt. That is something that most folks maybe don't have a sense of, and that comes into play with these cases all the time. Then factors that prosecutors consider in making the charging decision. We talked about how members of an MDT might potentially have input in that process. But it's a complicated calculus that the prosecutors have to go through, and that may not be transparent and may not be understood by lay people. So I think, and then Tara already talked about the role of a grand jury and what can and cannot happen with information that is discovered by a grand jury. Cross-training sessions and education at the start of the MDT, and as Tara mentioned, MOUs can be a way to sort of address some of these things at the outset. But one thing to keep in mind is how we define success as an MDT. And do you necessarily think that it is whether a case is prosecuted, or is it some other metric, or does it vary from case to case? I put that here as something to think about, not necessarily that I have an answer for you, but The prosecutor and the MDT may define success in different ways. Next slide, please. I think Tara already touched on a lot about information sharing and the varying confidentiality rules and expectations, whether you are a prosecutor or an advocate, or a civil attorney or an APS worker. Team members may not understand what is and is not confidential and for whom and why. And then the prosecutor's discovery obligations can also come into play and can also have an impact on victim safety. So, yep.
And there was a question that Tara might want to address around APS turning over files. Tara, I don't know if you can see the chat box.
I can't, but I can.
So basically the question, and Karen, I think, Karen, are you still on? Yes. Karen, if you want to, so she's asking around, does APS regularly copy their file and provide the prosecutors a certified copy? And in the boroughs, they've had that option, and there's a divergence of opinion. Karen, is that fair? That you want to, you're muted, but you want to speak to that a little bit, and Tara, maybe you can.
Yeah,
I can. Well, what I can say is that it does depend on your data practices or your data practice statute in your state. In my state, APS is able to share and does so regularly. They don't automatically do it, of course. We have to ask for it as part of the case. Usually, it's part of the law enforcement's investigation. So I'm getting it that way. And I actually will want to call the APS investigator as a witness in my case. I'll certainly want to interview them. It really depends, of course, on the case, but I don't know that we can answer that for all jurisdictions, because I have worked with other communities in other states where their statute is a hard no. They're not able to share the information. So I think you need to get a legal opinion from whoever at the county, in your county does the legal advice for APS, if it's county versus state. Sorry, that's not a very good answer, but it's just.
No, it is. It is. I guess, it was something, it always comes down to within our, like obviously the police department, if they have it, it's concerned, we have it. Adult Protective Services, it's really not something that we have control over, but more and more, I was the minority in saying we don't turn it over. Sometimes the case files are very extensive, but they can work either way, right? They could be good for me and they can be bad for me. There are sometimes conflicting reports inside of them, but overall, the way it's looked at is just like hospital records, right? We regularly subpoena hospital records. So I never used to turn over the APS records, but with the expansive discovery obligations now, I do think it's something that we need to regularly get. Yeah, I just don't know if our APS knows that.
Right, that actually was an issue for us very early on, that APS didn't think that they could, and so they didn't. And then no one ever fought them on it because they just thought, oh, well, they can't do it. They can't turn it over. They thought they couldn't turn it over, so they didn't. And then we learned, oh, actually you can. There's a statute that allows you to turn it over. And so let's talk about what that looks like in terms of, do I need to, I need APS to tell me if there's something in there that I need to have, for example, have the judge do an in-camera review on. There's, yes, you're right, there may be conflicting statements in there. Those exist. And so that's a style thing. I personally, I prefer to know everything about the case, and then I'll deal with it. I don't know that it's helpful to just say, okay, if I don't get the APS file, then I don't have to know about if there's any inconsistent statements. If there's an inconsistent statement, well, I want to know about, okay, does that mean that there's an inconsistent, you know, how damning is that to my case? I mean, it might not be damning to it might not be a problem in my case. It might be. I think that's part of our analysis as lawyers on the case, is looking at everything that's out there, and it helps make your determination as to whether you think you have a strong enough case to charge, whether you have a strong enough case to take to trial. Yeah, I think it's important to have the whole file and just look at everything.
Sometimes not, you know, we don't even know there is an APS case. You know, it comes to us in a variety of ways.
Sure.
So, you know, I think it's something that we always have to call up and say, do you have one?
Yeah, that's what I do. If I get a case, I just, that's my first call. And I should have mentioned this earlier. I don't know if everybody's still on the call, but in some jurisdictions, you may have to establish, for example, that the victim is a vulnerable adult. That's a Minnesota thing, but I think it's true in many states. And APS is my first call to find out if, or the NDT, if we have a meeting, and find out, oh, is this person, do they meet the definition? Are they getting services from APS? If they are, or is he or she on APS's radar? Because you also then can get prior incidents of, you know, that may have occurred that aren't part of your case necessarily, but are certainly a history that you want to know about. So yeah, I think you have to call and ask and find out if there is in fact a file. If APS is working with that person or on their cases, they may or may not.
So let's kind of, we're losing folks, and I think Anna has an evaluation survey to put in the chat before we lose too many people. And Laatsch, is there other things you want to say?
No, I think Anna will send.
Sarah Patet could talk about this all day long. And
I'm sorry, guys.
No, it's really, really good. And I know Anna will be sending out the slides and they have our contact information on them. So if you take a look at them and you have questions or you want to follow up with either of us, please shoot us an email. We would be happy to follow up with you or, you know, have another conversation about this. Tara, is there anything you wanted to add in closing if we kind of wrap up?
No, I think I've said enough.
Thank you, guys. I'm sorry we ran over.
Thank you. That was great. Thanks.